My name's Bob Leake, regional engineer out in Vernal, and I've been there for about 31 years. My topic is advanced water rights, and so it can be just as boring or I don't know that we can get exciting, but we'll see how it goes. We'll be talking about non-use and so forfeiture, non-use applications, shares versus rights. Forfeiture. Why do we have forfeiture? When you look at this state, we know it's a very arid state, and as the appropriation doctrine developed out here in the western United States because of the arid nature of the western United States, the idea was to benefit the state the most that you can economically, and the way you do that is you put as much water to use as you can. And so if somebody wasn't using their water right, then it's to the benefit of the state to have somebody else put it to use. And so that was where basically the idea behind forfeiture is if you're not using it, somebody needs to use it, and so we'll let somebody else take a shot at it. This picture is actually from an area out in our area where this obviously hadn't been irrigated for a long time, and so you see things like that. So what happens if you don't use your water right? It used to be that the statute read something along the lines that if you don't use your water right for 5 years, then the water right ceases. And that was about the extent of it. As people got looking at it, well, what if 100 years ago it hadn't been used for 5 years or more, and then it had been used continually since then? If someone brought them to court and was able to prove it, then that water right would be gone. And well, maybe that'd be maybe we ought to protect those people. So they came up with what we call the Lazarus Rule. And so if you put a water right back to use for 15 years and no one take you to court before the end of that 15 years, then the water right is brought back to life, and that's how the Lazarus Rule got its name. So if you don't, and it used to be just that the water right ceases. Well, what did that mean? So then things were clarified in the law and said that it had to be through judicial action that water right was lost. So it wasn't lost, but it was subject to forfeiture if you didn't use it. Now, if it does revert back to the public, then that water is then available to other appropriators in priority. And if there's excess, if there's water that's left over, if it's in an area that's open for appropriation, then someone else could file for that water right, or file for a similar amount of water. Let's see here. Wonder which one. Let's see. So the judicial action, in order for a water right to be forfeited, it has to be through judicial action. That can be brought as a lawsuit by any party, or it could happen in a general adjudication, or it could happen that the state engineer could file on a specific filing to have a water right forfeited specifically rather than as part of an adjudication. One of the things that happens in a general adjudication is once a water right is included in an adjudication and then that is signed, then that is, or is it when it's signed, or is it when it's, anyway. When it's through the adjudication, at that point, then you can't claim any non-use prior to the adjudication. So if something is going to be forfeited, a water right that was included in a general determination of water rights, or what we call an adjudication, then that is protected from non-use for a period that preceded that adjudication. Let's see. Now, after the adjudication, any non-use after the adjudication would count towards forfeiture. And another thing is that if water is let to run to waste, that is also considered part of forfeiture, could go towards forfeiture. Now, it doesn't apply if, and I have a whole bunch of slides, and we can go through every one of them if you want, but that's just kind of reading the slide. You can read the slides. But basically, the legislature came up with a whole bunch of reasonable times that you might have had a good reason not to put the water to use. It's under lease to someone else. The land is in a fallowing program. If your source of water didn't produce for a few years enough, you're in an extended drought, and so those are just a whole bunch of different reasons why forfeiture might not apply, and those were listed, and those are listed here. And rather than go through all of them, you can read them. Unless you have a question about any of them, we'll just move through those. Now, forfeiture, and one of them is that there is an approved non-use application. So we do have non-use applications that can be filed to protect water right. And an approved non-use application stops the clock for non-use. It doesn't protect a water right. Say the water right hadn't been used for 20 years. A non-use application is filed, and someone takes that person to court to have that water right forfeited. It doesn't protect them backwards. It protects you forwards from the time that was filed. And the filing of that or the approval of a non-use application does not constitute beneficial use. So you can file that, but the idea was, well, I can file a couple of those, 3 of those, and I can get my 15 years beneficial use, and then my water right is resurrected. But that was changed to no, that doesn't constitute beneficial use. So you can't just file non-use applications to resurrect a right. Now, why would you file a non-use application? Well, this is actually a picture of, if anyone's been to Kidney Lake up in the high Uintas, this was the dam failed. And that's one of the, if you have some reason that you're not going to be able to use your water, you can file a non-use application to protect it. Actually, this probably would have been protected under the other provisions because it was up in the wilderness, and they could have said, well, we're doing our best, and we're doing it as fast as we can, but there's all the federal regulations. And one of the interesting things is that a shareholder can file, and one of the reasons for that is if a canal company's water right is reduced, typically through a general adjudication, if they have a water right for 10,000 acres and we do the adjudication, it turns out they're only irrigating 9,000 acres. Where's the other 1,000 acres? What happened to them? And if their bylaws are written, if their bylaws allow it, then they can retire the shares that are associated with those 1,000 acres. Now, a shareholder can file a non-use application based upon his shares. He has to, let's see, I'm trying to read that with my, he has to give written notice to the canal company when he does that. I can almost read it easily, but sometimes not. So do you have any questions on forfeiture and non-use? What, if you'll wait for the microphone.
You talk about the 1,000 acres. If they took it out of their 10,000, that wouldn't change the duty, right?
I'm not sure what you're asking.
Well, the duty of the 4 acre feet per share, that wouldn't, if you were to take those out and forfeit the shares, that wouldn't change the rest of the shares in the company, would it?
It doesn't change the rest of the shares in the company if the company has it written. It has to be in their bylaws that they can retire those shares.
Okay, thank you.
Yeah, otherwise, then all the shares would have, if they don't have it in the bylaws, then all the shares, yes, would be reduced. So they'd have now 9,000 acres, but they might have 10,000 shares. Yeah.
One more question. On one of your slides, it says a public water supplier conserves or holds for the reasonable future water requirement of the public prior to May 5, 2008. Are you referring to the 40-year plan? It's not uncommon to have a subdivision with hundreds of lots and hundreds of acres. Acre-feet waters are conveyed to the agency, but they are not used immediately and perhaps exceeds that 7-year threshold.
No, this is forfeiture. The 40-year is that you're talking about. 40-year plan has to do with applications that have been made that have not been perfected. Okay. Where this is for a perfected water right that they're holding it. So it hasn't. They're not using. So they have a right for say 5 CFS, but they're only using 2 CFS. And they're holding the other. The other 3 they're planning on using in the future, but they haven't yet. So that was quick. Now, a non-use application can be approved or rejected by the state engineer. And the state engineer is given direction. The law says that the state engineer shall grant a non-use application if the applicant shows a reasonable cause for non-use. And then the reasonable cause for non-use, there are a number of things that's listed in the statute that it includes. It doesn't say these are the only things, but it says these are reasonable causes include these things. There's a depression, financial hardship, water conservation efficiency practices program, water recovery. There's legal proceedings going on. But it's basically kind of like the other. If it's a reasonable reason. If it's reasonable, then the state engineer shall grant the non-use. This is a slide that just shows there's a I-80 there going through Colville, and there's some land with the intersection where the interstate is. There's probably some irrigation that used to happen there. So there's probably at least a partial non-use on some water rights there, unless it's been moved somewhere else. But have a question?
Backing up to
If you hold on just a minute
says-
to get the microphone. Yeah.
Okay, it says on that previous slide, water held by a public water supplier for the reasonable future needs of the public is a reasonable cause for non-use. So if someone does a study and finds out that they can set their water aside for future use, do they also need to file an application for non-use, or is it just automatically understood that if their request to not use that water, to reserve it for later use, it's in non-use automatically? You know what I'm saying? They have to file a non-use application.
What you're reading is shall grant if. So if someone files a non-use application and uses this for the reason, then the state engineer is obligated to grant the non-use application. Now, if you look back at the slides that we did before, it's actually somewhat similar. But if I was, if it seems like that was one of the things that non-use wouldn't apply, it seems like for that same thing.
Or if the water is reserved by a city for the reasonable future needs 40 years from now, and that's approved, then do they also, when that's approved, do they have to file an application for non-use?
If they do, then it is certainly absolutely clear, because then they have a non-use application that has been approved. So there's no question. If they file that and they have that, and that is the reason for doing it, it's on a perfected right, and then the state engineer would be obligated to approve that non-use.
They would want to do a non-use application also, in addition to their study, right?
Yeah, if as a result of the study, they decide they can use the study as to show the state engineer
Evidence that they're going to use it in 40 years. Yeah.
that non-use application should be approved. Yeah.
Okay.
So, just as a review, when is a water right not subject to forfeiture? There's some questions here, and what protects a water right from forfeiture? So those are things to think about.
Got another question.
If you use the water once in 7 years, is that showing use and you're not susceptible of losing it, or?
If you use it once in 7 years,
Yeah, you say, I mean, because you can do, if you go 7 years without using it, it can go up be
so
taken
if you
away
use the water, if you
once
use
in the
your
7 year
water,
period.
then if someone takes you, sounds like that's not 7 years, but that's going to be for the court to decide. If someone takes you to court, if you're not taken to court, then it doesn't matter. And if you're taken to court, then the judge will have to decide that. It probably depends upon how much water you used. If you had water for 10,000 acres and you irrigated 1 acre during 1 year of 7, it's probably not going to save it. If you irrigated 1,000 acres 1 year in 7, then I think that'd protect it. But I'm not the judge. They've made that clear, right?
Yeah. Thank you.
Okay, so now shares versus rights. So I've got 10 shares out of the creek. What does that mean? Think about that.
Shares come down the creek every year.
Well, I don't know how a share comes down the creek unless it's just a piece of paper. It's a stock certificate that's floating on the creek. I don't know what a share coming down the creek means. Okay, what's a water right? Shares versus water rights. Okay, a water right is a property right. It's created according to statute. We spent a whole bunch of time yesterday talking about that, so we're not going to go over that. And entitle someone to divert and beneficially use the water. And it's pertinent to land if there is a unity of title. And the ownership transfers with the land unless the water right is severed. And the county recorder is the office of record of ownership of water rights. Okay, so keep that in mind. And now we'll go talk about shares. What's a share? Go back to that. I'll go back to that later. Okay, so a share in a water company, you got equal interests into which the entire stock of a water company is divided. Now, in the example I've used, 10,000 acres, it would be common to have 10,000 shares, but that doesn't necessarily mean that. I have a tiny bit of shares in a canal company that irrigates 10,000 acres, and it's 10 acres per share. There's another one in the valley that's 20 acres per share. So a share doesn't mean 1 acre. A share means it's a division of the company. Okay, so it entitles the shareholder to a proportionate share of the water. And it's not appurtenant to the land. The ownership is transferred by the company based upon the stock certificate. So when I obtained my stock certificate, had the stock certificate from the person that I received that from, took that certificate in, they canceled that one and reissued one to me in my name. Now, we'll go back to that 10 shares in the creek. What does that mean? Most people, if they say 10 shares of water out of the creek, they mean I've got 10 acres that I can water out of the creek. But that doesn't, if they're talking about it that way, it's probably a water right for 10 acres. Now, I have a question over here. Just hold on a minute. Let's get that microphone over to you.
Most people, when they have a share of water, maybe different water, but I know in our area, a share of water means a certain amount of water. So for so many hours, like a share could be 1 hour or an hour and a half. And as far as the amount of water, it depends on what water comes down the creek.
Exactly.
So you
But
can
the
have
share-
a share, but you cannot say you got a share that's gonna irrigate an acre of ground. It may only irrigate a quarter acre of ground if there's no water. In a case where you have mining companies and different things that take the water over the years, the shares of water
Okay,
may be smaller and smaller and smaller.
the amount of water available per share might become less and less and less. That's correct. And those are one of the things that we look at if there are change applications filed on shares or on any water right. We look, okay, how much water has been available under this water right, and we look at that. But the share itself, if it's an irrigation company, the irrigation company has a right for so many acres. And so their water right is based on acres. Now for the individual, it comes down more how much water am I going to get based on how many shares I have. And there are many places in the state where it might be a 4 acre foot per acre duty, and you might be lucky to get 2 acre feet per acre based upon a share maybe that might be, that on face value would be, say you have 10 shares for 10 acres, but instead of getting 40 acre feet, maybe you're lucky to get 20 acre feet in a year, but it's just the way it comes down the creek. And then the commissioner gets to divvy that up. And then, so mention change applications by shareholders. How do shareholders file a change application? Do they have the right to do that? Okay, the law says they do. And they have the right to, they have the right, well, but the canal company, canal company also has the right to, it's their water right. And the way we used to do change applications, and still do them sometimes that way, is that the canal company, well, the shareholder would go to the canal company and they would take a change application. We'd help them prepare, take it to the canal company and say, will you approve this? Canal company signs it. It's in the name of the canal company and it just moves forward. And we still do stuff like that if it's just kind of moving water within the canal company. But these the change applications based on shares, what's in the statute is more for when people are taking that water out of the company and using it for another purpose. But even if you're using it in the same way, we've had one filed just recently in our area where a person wanted to use it in the canal company, but it was a different, it was actually, he was going to run the water, he was going to irrigate the same land, but he wanted to take the water that was represented by his shares from a different canal so that he would have pressure. Because he was at the head of his canal, and he wanted to be at the bottom of the other canals because they're in pipelines, so they had pressure. And he took that to the canal company, and the canal company did not give him approval. So what does that mean? We're going through these, I'm not actually going through the slides, but they're all kind of in there. I'm kind of covering some of this stuff. I guess that's on the next one. So what happens? The law was just changed recently. So what happens if they don't respond? Canal company has 120 days to respond. If they don't respond, what does that mean? Well, it means that it's approved. It's considered approved. So the applicant takes that change application that he took to the company and asks them to, and so they take so that we're actually out of time, so we'll have to hurry here. So the shareholder takes the change to the canal company, asks for permission to do that. If they give him permission, he brings that written permission, or the other permission could be they could sign the change application. That's the simplest, is that they just sign the change application as a company. Bring the evidence that the canal company has approved it, and it might be that it's evidence that the canal company was given the application, had the 120 days, and didn't respond within that time. You bring that to the state engineer. There's a whole bunch of things that the company can consider as far as whether to approve it or not. There are certain things that are, and these are listed here, that the company can read. Basically, it comes back to it's reasonable. They're reasonable things. If it's going to, and rather than go through all of them, but they're reasonable things that the canal company can use. Just it's not because I don't like him. So the canal company has responsibilities, the shareholder has responsibilities, and they each have to follow through on those responsibilities. That the applicant has to develop it. They have to follow through. So those are, let's see, you can look on the specifics there through the slides. See, I didn't try and keep up with the slides, sorry about that. But so if an individual wants to file a change application based on shares, what do? So these are review questions. When an irrigation company receives a request to file a change from a shareholder, what should they do? So another thing is an irrigation company could incur liability by all sorts of different things. What are some of those things? Is a share the same as a water right? So, any questions? Comments? Okay. Well, thanks for your time.